Okay, Ma, over to you, Ma.
Thank you very much, and good afternoon, distinguished learned colleagues and all our participants and our speakers and friends of the section on legal practice and the section on business law of the Nigerian Bar Association that has joined us this afternoon. It's my pleasure to welcome you to this joint webinar that's been organized by the Technology, Media and Communications Committee of the Nigerian Bar Association section on legal practice and the Sports, Media and Entertainment Committee of the MBA section on business law. I think this collaboration just reflects the growing importance of cross-sectional engagement within the MBA and the willingness of the Nigerian Bar Association section on legal practice and business section on business law, to continue to think of areas where we can work together as one, particularly in these fast evolving practice areas. So I really am very glad when I saw the theme from deal room to courtroom, when sports and entertainment deals go wrong. This theme is both timely and for me very practical. As we all know, sports and entertainment industry is really expanding, and so will our legal, commercial and dispute related challenges continue. And what tends to happen in these sort of areas is the intellectual rights, maybe all kinds of broadcasting arrangements that are taking place. This seems to always be okay when you're coming together to have your deals. But when the deal fails, lawyers must be equipped. And that's why we're all here, to see not only how do we draft effectively, but how do we manage the risk and resolve our disputes strategically and effectively. So I commend both the leadership of both committees for this initiative, particularly our own Mr. Fernandez Marcus-Obiene, the chairman of the MBA section on legal practice of the TMT committee, and Ms. Tolu Olaloye, the chairman of the MBA section on business law of the SME committee, for driving this important conversation. We're privileged to have distinguished speakers, and under the expert moderation of Rita, we have Max and Kodichi and Ibogu. I'm confident that this session will be insightful, rewarding. I encourage everyone to listen, actively engage, and take advantage of the opportunity to learn and ask questions. I do appreciate the vision of, and I thank my chair of the section of business law, my colleague, Mrs. Ozofu, the chairman of MBA section of business law, for both of us making this collaboration possible. So once again, I welcome you, and I wish you a productive and enlightening session. Do have a good afternoon as we listen. So thank you. Thank you for joining us.
Thank you so much, Madam Chair, for your kind words and your opening remark. I think I'm good to start now. I don't know if my panelists are here. Maxi-Kombe, are you here?
Yes, I am, Rita. Thank you. Good afternoon.
Okay, good afternoon. I call Max. Okay, I do call Max my mentor of life, even though he won't agree. But please, for today, let's just agree that you're my mentor of life. In 1 minute, Max, can you just give us like a brief background, like a short bio about yourself, and I'll move on to Ms. Kodichima.
Okay, thank you, Rita.
Max?
Hope you can hear me.
Yes, please.
Can you hear me, Rita? Confirm you can.
Yes, I can.
Good afternoon. It's a pleasure to be here at the SLP and the MBA this afternoon, looking at what I think is increasingly becoming the future of legal practice. Sports and entertainment is a huge area that we should tap into. So just a little about myself. My name is Maxi-Kombe. I'm the founder and principal of Everlaw Associates, a commercial law firm. Amongst others, I've always been interested in intellectual property and technology law, and I followed the trends in that area for a while, and I hope to share some of my knowledge in that area this afternoon. Thank you, Rita.
Thank you very much, Max. Ms. Kodichima, same thing as Max. Can you introduce yourself in 1 minute, please? Thank you.
Thank you very much, April Moderator Rita. Good afternoon, everyone. My name is Kodichima Anibogu. I'm a senior associate at Jackson Etienne Edu, and I head the commercial intellectual property team, as well as being the deputy sector head for the entertainment media sector and technology sector. So this is a huge, platform and opportunity to be able to shed more light on, what we face, what I come across daily in terms of being able to advise clients in that space, especially as we all know where Nigeria in terms of entertainment, media, where we are right now, kind of where the next big thing or where the current big thing. So there's a lot of focus there. There's a lot of money to be made. There's a lot of employment opportunities there as well. And there's a lot we can be doing as well as lawyers to support and better promote the industry. So happy to be sharing insights on this. Thank you very much.
Thank you very much, Ms. Kodichi. I don't know if the chair of the Sports, Entertainment and Media Committee is online. Please. Dami, can you confirm if Ms. Tolu is online? Okay, maybe we'll just carry on. But my first question is going to go to you, Ms. Kodichi. So, in your experience, when parties walk into deal rooms, what would you say that parties are usually excited about when it comes to, making creative deals as it applies to the sports media entertainment sector? What are those things that you usually see? Because I've seen it, I think it was a movie where the guy came in unprepared, but his shark just knew his stand and he wasn't willing to back out. So what are those things that you've noticed in the course of your experience, and any tips that you feel lawyers should learn from your experience?
Okay, thank you for that question, Rita. So what I find is that creatives, especially in the entertainment space, even for sports as well, these performers really just want to perform, and there is that kind of focus and interest in showcasing their passion, right? So there is a money focus, and there's as well a platform focus in terms of wanting to be able to get the best deal, what they believe is the best deal, in the sense of, okay, how much can I earn out of this specific deal? What am I getting out of this? If not, let me not just say money, I would say an exchange of value, right? What do I get out of this? And most times the challenge tends to be that those in the entertainment space, beyond the entrepreneurs, the business-minded people, most of the creatives, if we use our talents, for instance, such as our music artists, you just want to make that money, you just want to, get that advance, not really knowing what an advance implies. You just want to be able to, have the flashy car, and then you want to be popular. So in that quest for popularity, a lot of things get lost, but that's usually the excitement and the push, even for a film producer.
We're told to answer question 1, meaning that it's compulsory.
So what I'm trying to say is that the focus.
Sorry, Ms. Kuchuma, sorry. Can we mute our mics to allow the panelists to give views, please? Thank you. Kodichi, please, over to you.
Thank you. So the focus is really, is excitement. Show me the money, what are we here for? What's all this for? I've paid my dues. If it's an established creative, if it's an upcoming, I want the platform to be able to showcase. You're going to give me the money that will enable me, show what I can do to the world. That is what tends to happen in that, yes, in those instances. So there are many instances where people are carried away. Quite right. Muted, yeah.
Yeah. Okay. So, other than when you see the excitement on your client's face, what do you as a lawyer learn from that experience, being in the same room and seeing all the behind the scene? Are there things that you feel lawyers should do to be able to calm, that excitement so they don't end up losing the goal?
Exactly. That's a great question. So as the lawyer, you are the clear head, really. And there's also the situation where you're almost wearing two hats. Beyond the legal aspect, you're looking at the business side. How does this benefit your client? Is this really the best deal being put before? So what tends to get lost in that situation is that there is an opportunity cost where people do not realize that, okay, I'm going into a film production agreement, or I'm being commissioned to produce a film. Is it possible, it's my first opportunity, do I just take this deal? Or is it possible that this script that I have present, the story that is about to be told is of way more value than as the creative perceives it to be. And of course, lack of knowledge as to what is even the going rates for commissioning agreements, what is even the going rates if you're even approaching investors in terms of what their investment returns can be on those. Even for performance of your services, let me use the instance of an actor as well. How much are you being paid for your image, so to see, or for your performance that will be used in the course of the service provision? So as a lawyer, you're meant to bear in mind have those figures on lock, that these are the expectations. Have your cap as to, my client should not be accepting anything less than this amount because this is the going rate. Nigeria, we are getting there. We may not be as formalized as standard as the Western world in terms of, and even maybe Bollywood in terms of the standards as to engagements, even for talent, cast and crew across. But then there should be, just like the way lawyers, we have our minimum charges and all that, schedule of fees, their expectations that for this, even if I'll call it quote unquote a waka pass rule, this is the amount you should be paid because your image is going worldwide. You're going to be everywhere. I mean, we're not. Now, we're talking about YouTube, we're talking about streaming, we're talking about how far digitization has gone. So there's no assumption that it's just a Nigerian movie. It's likely to be seen everywhere. And that kind of conversation, that should stir the conversation. Fine, there might not be immediate payments for this particular performance, but are there royalties? Are there considerations where, based on performance and how well the product does, I'm using a film, for instance, should those considerations be put in place? Those are the kind of things that as the lawyer, you expected to come in with that mindset, come prepared with your kind of benchmarks as to expectations, and also help, because creatives as well would want to close deals fast, but you're going to have to pump the brakes so that you're getting the best for your client, which is why you're there anyway.
Max? Max, can you hear me?
Yes, Rita. Yeah, I can hear you.
Okay, so great. So my question to you is on when discussing sponsorship and endorsements, right? Are there areas where a creative person or a sport athlete may have issues with in terms of morality clause? Because I'm not sure morality clause is something that we take seriously within the Nigerian perspective or the African perspective. But you find out that internationally, morality clause or any other relevant clause that you would end up telling us about is something that's, these creatives or athletes do take seriously, especially now when you're having AI-related conversations. So how do you align all of those interests when discussing things like sponsorship and endorsement deals, up until when you decide that there is a breach or something and then you need the court intervention?
Okay, yeah, thank you, Rita. And let me also thank Cody for some of the light she has strewn on the subject. And I think one of the points I want to take from her and build up on is that as a lawyer in this space, when you find yourself advising clients, there's indeed a need to understand the business a little bit more. And it's a field where the business is fast evolving. Take, for instance, sports. There was a time when sports was just sport. A sportsman was just a sportsman, and he was just out there to train and, give his best in terms of physical exertion, during the sporting event. But increasingly, sports personalities have become more of business and entertainment personality than they are even sports personalities. I mean, they make a lot more of their money off the entertainment side of their work, and of exploiting their image than they might even make from their actual physical exertions, in the field. So talking about morality rights, it's become a hot topic, and you rightly said, Rita, AI has become something else that has made the conversation about morality rights to be, a hot button issue. So first of all, we need to understand, that the foundation of a lot of, entertainment deals, sports deals also is copyright law, really. So I would say, for instance, that without copyright law, the entertainment industry would not function at all, because the very thing that keeps that industry together is the rights that the creatives have. So be you a performer, an artist, an actor, any of the spectrum you find yourself within the entertainment industry, copyright law really is the foundation that gives you any kind of protection and ensures that you can get maximum return from your creative effort. But however, why I say that is just to emphasize that when people think about copyright, they only think about the economic rights. They forget that they are the moral rights. So the economic rights would be the right to control how your creative work is exploited. So nobody's allowed, for instance, to make copies of your work and sell to members of the public and just take that money and pocket, perhaps without getting a license from you. So that's good enough. That's really about protecting your money. But the other side of it is that you have a right to be recognized as the creator or the author of a work. And apart from having that right also, that right by extension now means therefore that nobody should use your work in a way that is contrary to the intention you had when you created that work. So when you take it broader to sports and entertainment personalities, you know that one of the most important sources of revenue for sports and entertainment people is they ride on the back of their popularity to promote brands, goods, and services. So therefore, everybody wants to associate their goods or their services with a popular person, because it simply means that if Lionel Messi wears, a top I created, for instance, a shirt I created, a jacket, then everybody wants to buy that. So, for instance, the French president, Emmanuel Macron, wore sunglasses during his address to the World Economic Forum in Davos just last week. Donald Trump, during his speech, commented on that glasses. At the moment now, that glasses has become a hot-selling item for that producer. So you can see that just because a popular person wore those glasses and, some issues arose around it, it has become, it's fast-selling at the moment. So because of that, it's a good thing, but there's a room for abuse. So it therefore means that you might have certain products and services you do not want to be associated with, who want to appropriate your name, your likeness, your image to sell their products. So that is where in drafting or in the deal room for sports and entertainment deals, you want to spell out those things clearly. Because you know that a sports personality, for instance, when he joins a football club, he sells some of his rights to that football club. That football club can use him on advertisements. We have seen billboards, for instance, for, I think which is the most recent I saw, but with a lot of those billboards where a sports team is advertising maybe a sports drink, and they put 3 or 4 of the footballers from that team. So if one of those footballers, for instance, is a Muslim who is opposed to alcohol, then there's an issue there. So in negotiating in the deal room, these are the things that, as a lawyer advising that sports personality, you should pay attention to. Ensure that there's a restriction list. You can use my image for everything else except the following. You have to spell those things out clearly. So there are a couple of other things, but broadly, I'll just end at this point by saying the moral rights, even though not economic themselves, are really important. Increasingly, people do not pay as much attention to the moral rights as they pay to the economic rights, and they later end up regretting that lack of attention. So thank you, Rita. I'll end at this point and allow us to take the conversation deeper. I don't seem to see Rita anymore, Cody.
Yes,
I don't know if you see her.
sure. I'm sure she will be back in.
Okay. I think while she's waiting to come back in, Cody, perhaps might want to add a few things.
Yeah,
And I might want to throw you a follow-up question from some of what you said earlier while we wait for Rita.
Okay, so I was going to add as well, beyond the moral rights clause, the morality clause as well for particularly sports persons and those that have become, like you rightly identified, they become influencers, entertainers, they're getting brand ambassador deals. I mean, understand for Mbappe, he has an image rights, 80%, he's retaining 80% of image rights in his current deal with Real Madrid, which normally, typically, the football club would give him 50-50 just to show the breadth, the popularity, and then the bargaining power and strength that he has, and also the work of the lawyer in being able to say that, my client demands more because of, you are able to show his performance or, that popularity that would tie all that in. It just brings to bear the strength of these soft kind of rights that come from, those recognitions beyond the copyright established ones and the likes. And then there's also the issue in relation to morality clauses as to the expectation of being an upright or an upstanding representative of the brand at the time. So if we all remember Tiger Woods, for the millennials and older generation amongst us, how that's completely ruined almost his career. Of course, it's picked up and the likes, but just the fact of that infidelity and what the effect was, he had a lot of brand sponsorships, and then to be able to come back from that. So when these artists, and even as lawyers, when we're representing, there are some clauses, there are some instances where you have to bear in mind that your client, you may not know the character of your client, but this might be a risky situation to be. Maybe looking statistically, what are the likelihoods that the person is not likely to fall? What are the likelihoods that the person is not going to fall afoul or definitely breach this contractual provision just because there is a tendency for this, a tendency for drunkenness, those kind of alignments, even for film talent and actors' performance in relation to nudity clauses, those kind of things where they might already be religious preventions or personal beliefs that would stop that. Had a case with a client in relation to a film contract, and then there was mention as to not doing anything that would discredit or discriminate against kind of the LGBTQ community, and then giving Nigeria's position, the legal position on how it is a criminal offense, so and so. Those are kind of like naughty areas to be caught in the middle, because it's like, what do you advise if someone is doing this? Nigerian law has already made certain provisions as to what is acceptable or not, but then this contract is coming to say this or that thing. You don't want the client to be in a hard place. So those kind of considerations should definitely be made in terms of what is the standard of what is considered morality. What do we lose out? Is a contract terminated because this person has done this? I think we remember the Kevin Hart's not being able to host was it the Oscars and the likes, because he had said something about a certain community in the past and how those kind of things affect. So those contractual terms are things that should definitely, especially for endorsements and brand ambassadors, people that fall into that role, which a lot of our entertainers and those in the creative space actually come under.
Yeah, thanks, Cody. Okay. I don't think, is Rita back?
Yeah, I'm back. Apologies. Sincere apologies.
Yeah, please, Rita. Yeah. So Cody added a few points to the question of morality clauses.
Yes, thank you so much. I was actually enjoying both of you's, contributions. But just to piggyback to an area that I actually like, which is on IP, and I would want Kodidima to actually answer this part, and then Max, if you have anything. So what IP rights do you feel are mostly underestimated when it comes to the sports and entertainment sector, especially now when we are having image right conversation? I think I saw a post this morning that Kabi, the guy that does like this, that's all he does. He sold his media, sold his media company for almost $1 billion, and some other person is managing his IP rights. Then we had, yeah. Then we had the Neymar conversation last year of buying the Pella's NIL, name, image, likeness. So the conversation is beautiful, but when you look at the Nigerian entertainment and sports sector, the business angle of IP is not being discussed. So your data, your image rights, your likeness. I think Matthew McCarthy recently trademarked his likeness, which is like an interesting conversation, area of how everyone is thinking forward. So what revenues do you project that creatives within the entertainment sector and athletes within the sports industry will start exploring? Maybe we now have to adopt an international best standard, or at some point Africanize it, or Nigeria it's some way the same way we've done with Africa and the rest. So what are your views with regards to the IP aspect of sports and entertainment sector in terms of monetization and revenue generation?
Thank you, Rita. It's a very key point. I mean, we will recall the Kiss Daniel lawsuits, right, in relation to even just the name. So typically in the clauses, we have it name, image, and likeness, going together as one clause, stating depending on what nature the contract is. If it's a film production, of course, you're going to be utilizing that for the sake of the film. So that producer would be getting the permission you would want, depending on whose side you are on and where you're coming from as well. All that needs to be borne in mind. So we'll say, speaking on the part of the talent themselves, the consideration, especially as a lawyer, who you are representing does matter, and everything can go either way. That's the beauty of contracts. It's this way, it's that way. But then it must be borne in mind that that is part of the value, even if specifically it is not the service being provided. For instance, in a film, I use a film project, for instance. I mean, I'm a popular actor myself, I'm a popular actress if I was, and then I'm coming in to play someone else. I'm not coming in to be myself. So that the main purpose or the crux of that contract is what to perform the service of, let's say I'll be Lola in a film, but that should not detract from the fact that who am I? What's my following on social media? What's my popularity? How is the movie going to be marketed? Are you going to rely on me, playing this role? How are you going to rely on me playing this role to be able to, bank or, generate the revenue, get the exact effect you want the movie to have? That should be seen as a value in itself. So we as lawyers, as you are reviewing whatever it may be, like we're talking about the Mbappe case, I'm talking about sports. He's coming to play football, quite all right. But we're already talking about image rights, retaining control, 80%, 70%, 60%. And what we have with Real Madrid is normally a 50-50 split. Everybody splits, whatever branding that you're going to be associated with at the end of the day, whatever the revenue may come across, how you would want to use it. But then you are now having permission, or you're having more control and more oversight and then approvals and to make that decision as to how exactly your image would be used. It must be borne in mind that it's a value in itself, whatever the overarching business of the day or the service being provided may be. For an influencer like we have on social media, there are some people that they might not be known for a specific thing, whether it's acting or singing or the likes, but they are just influencers. So typically their brand contracts or brand endorsement deals would just focus on that. It's about your image rights. We're going to use you in this specific way, this and this. So the value there is clear, that the focus is image rights. But where it is something else as well, you're performing a service, it must be borne in mind that that person's recognition, the fact that the person is being recognized, and the fact that there is value in it, right to publicity, right of privacy, depending on which jurisdiction you go to. US, UK, there's been a lot of disparity as to what it is. In Nigeria, maybe we've had to rely on, passing off because there's no specific law in place, which data protection laws are now coming into sort of answer. I know there was a recent case in relation to Adoni Ade, right, and where they were able to rely on false lights, so defamation, but maybe like a lesser form of defamation where it is like you're portraying, a blog is using your image or is stating that this person has done certain things, and you're like defaming the character of the person, and it's like, oh, you're portraying me in a false light. This is not who I am. This is not what I represent. It's going to negatively affect whatever projects the person has in place, showing you how strong that is, image, likeness, and name is, and that there is value specifically being ascribed to it. So I think the advice at the end of the day would be make consideration specifically for that in the contract. Bargaining powers differ. It may not go the way that you want, but it must be borne in mind that this is seen as valuable in itself, and it can be exploited in different ways as well. And that consideration can be made. For instance, if it's being used for a film project, restriction to that film project, allowing the person to be able to do whatever else they're doing with their own image rights as they wish, in the Kiss Daniel case, he had to go change his name. He was, he went and set up his own thing separate from them, and it was against the contractual arrangements. So those kind of considerations have to be borne in mind. To what extent image rights is being used, depending on what service or what the overall project is. I'll leave that there.
Thank you very much for that insightful breakdown. So I'm going to go into another interesting area that I feel that most Nigerian creatives, I think mostly the creatives, not the sport artists. I think the sport artists just have like 1 or 2 cases, but you find out that most creatives would rather do like a social media call out, right? So Max, this question is to you. How damaging is public litigation to brand equity in sports and entertainment? And have you seen a strong contract still fail in court? If
Rita,
yes,
confirm you can yeah.
Okay, then over to you.
So confirm you can hear me.
Yes, I can.
Okay, thanks. Yeah, thank you very much, Rita. Yeah, this it's actually a funny issue, the issue of how public litigation intersects with the entertainment and the sports industry. I would say there's a different there's some difference between the impact. Yeah, there's a difference between the impact public litigation has in a sports setting and in an entertainment setting. So let me use 2 examples to drive home the point. Everybody knows Snoop Dogg. One of the things that made Snoop Dogg most popular was the case they gave me. That was a high stakes litigation he was involved in. And for him, it turned out well. It made him popular, it gave him publicity. And of course, we know in the entertainment industry, every publicity is kind of, desired publicity, because all you want is your name to be out there, whether for the good or within the
Hi, Max. I don't know if you can hear me, but I can't hear you at all. I don't know if the participants can also hear you.
Okay, so can you hear me now? My apologies, Rita.
Yes, I can hear you now.
Okay, sorry about that. I just switched the internet sources. So I was saying that the impact of a public litigation is and
hi, Max.
Yeah, hope you hear me now.
Yeah, I can. I don't know if others could hear you.
That, yeah. So I said I was illustrating the different impact of a public litigation in the sports scene and the entertainment scene. And I was using 2 cases. One, Mother was the case they gave me, Snoop Dogg. That case made him popular. It gave me a lot of visibility, because the media came there, and it's free publicity really, because the media would report on a court case. They don't want any money. So it gives that level of publicity. Another example of a litigation that shows the impact it has in sports, the opposite impact, is the Bossman case. So Bossman was a footballer whose case is very popular and is the basis for for players have been able to get free transfer in the football space. His case is very popular because the case set the precedent that changed a lot within transfer rules in football. But unfortunately, Bossman himself could not play football for 5 years while that case was going on. When that case was over and he returned back to football, he suffered a lot of injuries. He went into depression. Ultimately, he retired from football earlier than he should have retired. And then by 2017, he had declared bankruptcy. So you can see that for the sports person, litigation is dangerous because the sports person's business requires that he has a short time frame, because age catches up quickly with the sports person. So he wants to give his best while it is on the side. So a litigation that in any way would impact his ability or his concentration. We have seen other sports people like Kobe Bryant and all of that impacted his, his performance on the court. But so the R. Kelly litigation, for instance, did not favor him because that came with a lot of moral baggage as well. So it just tells you that when it comes to litigation, and this is for lawyers generally, that we need to be careful how we go into litigation. Even if you use litigation in the sports or in the entertainment sector, you must be strategic about it. So sometimes strategy might mean going to the court that gives the most visibility in an entertainment deal, for instance. And then of course, we also have to be careful about trial publicity, because the entertainment person is going to want to put all the proceedings in his case on social media, which can also become a boomerang effect for the lawyer, because of course that puts the judge under some kind of pressure. So I've been in court before. I've seen while a high-profile entertainment case was going on, and somebody was recording secretly and actually streaming, and somehow the judge found out, and it became a huge issue. The person was almost committed for contempt of court. So it's about advising our clients right. So in the sports sector, you don't want to get into litigation. If there's opportunity for ADR, which there is, because, for instance, in football, the FIFA has a full stack procedure for resolving disputes outside of the courts. So you should always advise clients in the sports industry to take those opportunities and not go for litigation. Litigation is rarely the best way to resolve sports disputes, particularly when that litigation is going to impact the performance of a sports person, in the game. Thank you.
Can you hear me? Yeah, great. So thank you very much, Max. There's a thing you like to do when you're doing your presentation. You make citations of cases. I know that people are always like, I'm one of those people that like to pay attention to the cases that you're eventually going to mention. So just do us a favor. I write the cases you mentioned in the comment sections for people that will be interested to read about. I will be interested to read about the cases, right? So thank you very much for that.
I'll do that.
Thank you. Ms. Kodichima, I have a question for you, right? And my question is, how often do disputes really come down to ownership and control of IP rather than money alone? What happens when exploitation of IP evolves faster than the contract, especially in this streaming era? I mean, we had the NFT phase. Now we are dealing with AIs, So how do you deal with conversations around dispute that will not necessarily boil down on monetization, but rather on ownership of the IP and assets that a creative or a sport athlete may own? Kodichima, are you there?
Yes. I heard two questions. So I think I'll take the one in relation to exploitation being faster, different means being faster than maybe the contract would have envisaged. But that's why when people tell us that lawyers are legalists is too much, these are the defenses and the reasons for such things. You cannot envisage. So in your typical intellectual property assignment agreement, so where you have your assignment clause, you would see, or any other future rights hereinafter so soon developed at any point in time all over the world within the universe. If there's anything bigger than the universe, we are going into that, the galaxy, whatever. You never can tell. We're talking about, we're going to Mars, space stations and the like. So you're going to see possibly cases where it's like, okay, these people were in a space station in Mars and this movie was played and there was no IP rights, territorial rights did not extend to those. That is where we are. That is where technology and advancement has brought us to. So those are the considerations that basically as a lawyer, you're drafting your clause. If it is an assignment clause, whether it's an assignment and requirement, you're drafting it as wide as possible. And you're making considerations such as all other future development of technology or future technology media, or where you are saying, you want to use kind of the ejusdem generis rule of just being express of you've given the lists, and then it is applicable. You're not going to want it to be a closed list, especially when there's an assignment, of course, because the court will be minded to always honor the contractual arrangement that the parties have come together for. And the beauty of particularly copyright law is that, a lot is subject to contract. There is the established fact already that once you are a creator or you are an author, you own the IP to your work. But where there is a contractual arrangement, where there is a transfer, that moves. And we know that with assignment, it is quite broad as to what you can assign and not assign. I can assign IP, but, just for Nigeria distribution, I can assign in relation to territoriality. I can assign in relation only to territoriality being geographical location. You can assign depending on the type of IP, just for reproduction, just for streaming, just for theatrical release, just for merchandising. It goes on and on and on like that. That is the beauty and the benefit. So as lawyers, in drafting those terms, we just have to be wise, because you cannot necessarily predict what's going to happen in the next 5 to 10 years with AI and with different methods of distribution, which is good for your client, depending on where, in fact, any side of it that you are. If I use a film production or a broadcast, like a sports broadcast, for instance, and rebroadcasting and the likes, the more distribution channels you have, the more the merrier, the more revenue streams and the like. So all that is actually encouraged. Just be ready to assign broadly, or if it's a license, right, exclusive, non-exclusive, depending on those terms, having those financial considerations in mind of what you are covering for the licensee, on the licensee's part as well, being willing to give enough value in order to have, that permission. And for the license, so would you say that, for the use of my music, for instance, across the universe, or songwriting for anyone else to, go and record and do the masters, assigning that actual composition as well? Will I say that, for the universe, this value I'm getting in exchange is what those considerations need to be borne in mind as lawyers when we're drafting? And then to the other point where you said ownership and control over payments, or the other way around, what tends to happen, I think I see that it's really more of an ownership and control issue, because that does determine payments at the end of the day. Who owns the IP, and depending on what has been contractually agreed. Because I'll give an instance, contractual ownership of the IP, right? But then I've assigned the economic benefits through royalties, through streaming, through licensing fees, to be collected by maybe a distributor or the likes. The fact that I have done that does not stop me as the owner from being able to determine other means of exploitation, dependent on what I have mapped out for that specific distributor or that specific person. So it is in that benefit that ownership and control tends to be more of the argument, because you're then able to determine payments, you're able to make different allege different claims to economic rights as well as moral rights, depending on if author is different from the owner at the end of the day. And we see that a lot in the Nigerian cases, from the Marcus-Obiene case in relation to was that Okafor's law. We also had those claims that were made in Shanty Town as to executive producer. There was that mixture, and I think that's also something as lawyers we need to communicate to our clients, when we're providing those services in relation to what those names mean. Because the Copyright Act, does not necessarily use the term producer. Maybe the new act does. I don't think so. We're talking about who owns I'll use a film production, because entertainment is so broad. There's so many different angles we could come from. Where if we say a film production, for instance, the law has already said, the person who makes the arrangements for the film to be made. And, then we just say that is the producer. But then you come and then you're seeing credits, and we have executive producer, we have this, we have that. And so someone who comes and finances a film believes that is gives them the entitlement, which was what kind of the case that was being made in Shantytown, that, you can't go and enter into an arrangement with another party for the sequel. I own the film as well. Oh, why? I'm the executive producer, I'm recognized. No. At the end of the day is what does the contract, say in terms of who owns? Was there an assignment? If there is no assignment clause, and I think that's something I'll really quickly point on, it is very key. And I just have to kind of sound a note as well to lawyers, because we do come across instances where people are not relying on Nigerian law in making those kind of claims, right? That's where technology may fail us, not giving us giving the accurate representations. People do tend to claim a lot, work for hire, make some work for hire claims. Nigerian law is not a work for hire situation in terms of ownership. Your assignment has to be in writing and it needs to be expressed. Without that, who owns what will clearly be what the law has said, depending if your contract does not speak to it. And that's something that as lawyers we have to bear in mind, so that we're not having some other disputes or potential disputes and claims up and down. And when you look at it, you're like, this will fail, immediately at the face of it, because you've not done the needful, and it's not even in line with Nigerian law. So definitely ownership and control is the major focus for everyone, because it still ties into payment, it ties into approvals, it ties into distribution, it ties into every other aspect of maybe monetization that could come up.
Okay. Thank you so much for that insightful response. I mean, the conversation as to territorial rights in view of technology is something that I feel that lawyers need to also pay attention to when drafting. And because of your presentation, I saw an interesting comment by someone that said, you and Max should share drafts of an agreement as it applies to this topic. So I don't know how that's going to work, if it's even going to be possible for my panelists to give you a draft. But I think maybe in the course of their presentation, before we close, they might share like maybe boilerplate clauses and tips on how to draft entertainment. And I think we did something on drafting of entertainment contract last week. So if you missed that, please, I think, find a way to get that record in bold. Thank you very much, Kodichima, for the insightful response. So I think I'll come to Max now. I don't know if Max is still here. Max, are you still here?
Yes, I am.
So I think I would like you and Kodichima to answer this one. And this is on enforcement, right? Where a party is trying to renegotiate their contract. So at what point should a party stop renegotiating and start planning for enforcement or litigation? Or if you are ADR, you're pro ADR, when do you start planning for ADR mechanism? I mean, if you look at the Taylor Swift, I think Taylor Swift's case is like the biggest renegotiation case study that we can actually allude to. And I don't know which Nigerian case, maybe Cynthia Morgan and Keith Daniel and who I think Ashake. I don't know. But you guys are the experts today. Me, I'm just playing guesswork. So you guys should tell us, when do you stop renegotiating and start putting your feet down and say, okay, this is what I'm going to do. If you don't want to take it, we are going to court, or we're going to explore ADR as the case might be. So Max, over to you first, and then Kodichima, you're next.
Okay, yeah, thank you, Rita. So first off, Rita, I'll say you are also the expert today and every day. So you are always our expert. So for me, my advice on this, it's an advice from a general dispute resolution point of view. Always go into a dispute when you have the upper hand. Never go into a dispute empty-handed. That's just a general principle in dispute resolution, and also applies in sports and entertainment deals. So you want to go to court when the pendulum is swinging most in your favor in the course of negotiation. So, of course, one point where that happens is when the money is already in your custody. So if there's going to be a fight, that is maybe based on a revenue share split and all of that, and you are the one who is collecting, and you are not done with all the collections yet, you might not want to escalate the matter to, a dispute forum at that point. When the money is being banked, then, or at least there's no prospect of the money getting banked soon, then maybe at that point you can think of going to court. Now, that's just a general principle. Generally look at because even if you go to an ADR forum, there's of course what we call the BATNA, the best alternative to a negotiated agreement, or WATNA, the worst alternative. So you want to ensure that you are negotiating, even if it is going to be an ADR forum, from a strong position. Same thing also with litigation. But specifically in sports deals, for instance, you might not want to go to court if you're going to court would involve, for instance, would have impact on the ability of that sports person to carry on with his sport. So an example, for instance, from Formula One is the case instituted by one of the former Formula One champions against Lewis Hamilton and the F1 organization for, I think, was the 2008 or thereabout championship in Formula One racing. And I think he's strategic because he waited until his career was over before he took up that case. Because if you do it while your career is still on as a sports person, it would have an impact on your career. So somebody mentioned in the chat, and I agree with her, that the reason why sports people don't even go to litigation is because, for instance, in most sports, you have a dispute resolution mechanism that goes all the way to the court of arbitration in sports. So usually that works out a little bit faster than regular litigation, and somehow it's a little bit more sensitive to the specific needs of the sports person involved. So for instance, when any of the major sporting events like the Commonwealth Games, the Olympics is going on, there's typically an emergency mediation and arbitration panel that is set up immediately to ensure they can resolve disputes on the spot. So there's a problem, somebody's about to run 1,500 meters the next day and a challenge arises. There's a dispute resolution panel that is on ground, ready to instantly in 2 or 3 hours give a decision to ensure that that person is not stopped from performing. So I mean, our own Beverly Agbakuba, who used to be the chair of the section on business law, sports, media and entertainment committee, was, for instance, in the Glasgow Commonwealth Games, I think that was in 2022 or 2023, was on one of the panels for mediation. So those panels go to the games, they are there, they're just waiting. If there's an issue, they resolve it immediately. But imagine if you are running 1,500 meters tomorrow, you've been disqualified unlawfully. You have to go to a Nigerian court to file a writ of summons. When is the writ of summons going to be served? When are you going to have a date for hearing? When are you going to have judgment? When you have to run tomorrow? So these are some of the things we need to consider. So for entertainment, you might not want to go to court for, in an entertainment deal when at the moment things are not really on the up for your client. So typically, for instance, one of the tricks we see in entertainment is that entertainers always create controversy just before they release a new work. So just when you release an album, it's about the best time to go to court, because maybe 2 or 3 weeks before, the news is already awash with the fact that this guy is in court with this person and that person, and then 2 weeks after, his album rolls out. So these are some of the little things you watch out for and determine when it is best to stop negotiating and go. But of course, the general rule is that when the opposing party is not willing to negotiate anymore, then of course at that point irrespective of all the other things I've said, you might need to, because of course remember that sports and entertainment deals are like any other, typically like any other tort, they are subject to limitation law. So in states, in places like Abuja and some of the states that have not modernized their limitation law, you have 6 years to go to court. In the states that have modernized their limitation law, like Lagos and a few others, you have 5 years to go to court. So it's, those are things you also have to put at the back of your mind to ensure that your client's claim does not go stale while you are still negotiating. And remember, of course, that the courts have said it, negotiation does not stop time from running for the purpose of limitation. So don't negotiate, forever. Once you negotiate to a point, it's better to go to court, file your case, and then come back, take an adjournment for further negotiation talks and negotiate. If you can reach a settlement, you file a term settlement. If you don't, then you continue your case. That way, your claim doesn't become stale. Thank you, Rita.
Thank you, Max. See why you're my mentor of life. And you were talking as someone that was tilting more to the sports sector. Like you don't like entertainment people and they are plenty while you're already away from it. Anyways, Kodichima, are you there?
I also don't like pay lawyers.
But I think Mike has really done justice to that in terms of having that strength, that positioning to enable where the best place that you should really, really stand. So I align with that.
Okay, thank you so much, Max and Kodichima. So I guess I don't know if I should be preparing to round up, but what I would just want Kodichima to answer is what, I think, or Max anyways, what advice would you give talents who see litigation as failure? Because there's this perception that going to court doesn't really work for Nigerians. It's more or less for, like they like to say, the person with the fattest pocket, right? And I don't agree with that. I don't know if you also do not agree with that. Or my question to you is, what advice would you give talents who see litigation as failure rather than strategy? And if you could rewrite one industry practice tomorrow, what would it be? Max? Okay, I think.
Yeah, okay, yeah, Rita, sorry. Yeah. So I thought I'd let Cody go first on this question, and then I'll add a few thoughts. If is Cody on?
I was bumped out, so I just got back. I did not catch the question. Yes, I actually was, yeah.
Okay, the question was on the mindset. Sorry, the question was on the mindset of creatives who feel that litigation is a failure. And how would you say litigation is a failure, or is just lack of a good strategy at the end of the day? And if you could rewrite one industry practice tomorrow, what industry practice would that be? That you would like to rewrite so things get better for us here in Nigeria and then within the regional aspect in terms of Africa and then looking at the international space as well?
Okay, so I wouldn't see litigation as a failure, really, even in the broader sense.
I don't know, is it my internet or I can't hear Cody? Max, can anybody hear me? I think Cody's network is buffering. Okay, I think Cody's network
Rita, I
is
can
buffering.
hear you, but I can't hear Cody.
I think
Okay,
Cody's
so maybe
network
I'll
is
take up the
buffering.
question
Can
and then
you
when she
take
comes
over?
back.
Okay, thank you.
Yeah, so I wanted to say I really would not blame any artist who feels litigation or who wants to avoid litigation at all costs. We still have a lot of challenge with our courts, and I see a question asked, I'll drop that into my answer. Now, unfortunately, in Nigeria, we do not have specialized courts for IP disputes. However, because IP disputes are largely copyright and trademark, a lot of it border on copyright and trademark. Invariably, they have to go to the Federal High Court because under the Constitution, the Federal High Court has exclusive jurisdiction when it comes to matters under the Copyright Act, under the Trademarks Act, and of course, other IP matters. So typically, but now that's another distinction people don't make sometimes. Except your claim touches principally on enforcing an IP right. If the claim is contractual, that means the claim is about, for instance, revenue sharing, not necessarily the underlying IP right. You're not arguing about whether the copyright is valid or not. I'm arguing whether the transfer of the copyright is valid or not. You are simply saying, based on the agreement we reached, my share of the income should be this. And because you did not properly account for expenses and other cost of production of the of the deal, therefore you reduced my share. Now that's a purely contractual dispute. You can take that dispute to the High Court of a state. You don't have to go to the Federal High Court just because it borders on IP. You can also take that dispute to arbitration as well, because that's another question we have not really touched, which is that there's still a lot of uncertainty about whether IP disputes can be arbitrated. Now, the answer to that question is a little bit complex, but I'll try to just condense it. Different jurisdictions in the world have different approaches to arbitrability of IP disputes. The reason for that is that most countries see IP as a public policy issue, because when the government of a country grants you a patent or grants you a copyright, essentially they are exercising a public duty to give you a sort of monopoly. So there's an underlying public policy consideration. So many countries feel that a private dispute resolution mechanism like arbitration should not be allowed to determine public policy issues. So because of that, we have that argument whether IP disputes are arbitrable. However, in some countries, they make it broad. You can arbitrate all IP disputes. In some countries, they narrow it and say, you can give an award in an IP dispute, but that award will only be binding inter-parties, between the two parties, it would not apply in rem. That means it's not applying generally. So for instance, the arbitrator cannot make a declaration that a patent is void or a copyright is invalid, because that would be an in rem pronouncement. So you can only say, as between the two parties before me, this trademark is invalid or this assignment of copyright was not valid. However, it doesn't bind the public. Now, but in other countries like Nigeria, the argument started from a very narrow base of people, first of all, assuming that just because the Federal High Court has exclusive jurisdiction on most of the IP-related matters, copyright and all, that therefore arbitrators cannot also exercise jurisdiction. But that argument has been shown not to be true, particularly in taxation matters. The reason being that if you make that rule, then almost every dispute that goes to arbitration that is commercial related, like oil and gas, would also not be arbitrable. So that broad rule doesn't work. So the more correct interpretation in Nigeria is that when the disputes involved are contractual, or the contractual elements of the disputes, that can be resolved by arbitration. But the parts of that dispute that border on the right, the existence of IP rights cannot be resolved. So what should happen in that case is that the arbitrator should only take his mandate on the contractual side and allow the parties go to court to resolve. So just to wrap that up to the question now. So I don't blame creatives who think going to court is a waste of time. Now, it takes a lot of time, it's expensive, it kind of can be a black box. You never can really tell how much you have to spend to get to the end of the transaction. So typically that is why creatives would prefer, or as advisors to creatives, you should advise them to go for ADR, for arbitration, because you can design your dispute, you can determine upfront what it would cost, how long it would take, what the procedure should be. You can design to fit your taste, and you can also have a dispute resolver who is an expert in that field, who understands the field and is able to give a decision that flows with the general thought in that field. So for instance, I won't mention the name of the judge, but we are all aware that maybe 3 or 4 years ago, a judge of the Federal High Court, a senior judge of the Federal High Court, who gave a judgment saying that a copyright without registration, at the Nigerian Copyright Commission is invalid. Now we know that elementary IP law is that copyright exists independent of any formality, including registration. So if we still have those kind of challenges, I won't blame any creative who is afraid of taking his case to the courts, where a judge who knows nothing about IP rights, who knows nothing about entertainment deals, sports deal, would decide it on just the general knowledge of the law that the judge has. So I won't blame creatives who are a little bit uneasy about taking their disputes to litigation. Like I said, I think for me, generally, both sports and entertainment deals, I would avoid the court if I can avoid it. And that is why from the deal room, ensure that you put a well-structured and negotiated dispute resolution clause that selects arbitration, and also select the arbitration that works. I'm currently in a dispute now, and we've had a lot of challenges. Now, that dispute, when they designed that agreement, they just simply said arbitration under the Arbitration and Conciliation Act, the old Arbitration Act. And under the old Arbitration Act, if you do not specify how many arbitrators would resolve your dispute, automatically defaults to 3. And this was a dispute that the total value of this was about maybe 50-something million. So, I mean, imagine appointing 3 arbitrators over a dispute of 50-something million. That's completely ineffective. And unfortunately, because the respondent did not want the matter to be resolved, we made a proposal and said, look, even though our agreement chose the default to 3 arbitrators, can we agree or sign a submission agreement to say, look, let's go for 1 arbitrator and let's go to one of the small claims, the court-connected arbitration centers, that would, of course, be a lot cheaper to resolve this dispute. Of course, because he didn't want it to be resolved, he refused. And once he refuses, your hands are tied. So you can see that a failure from the deal room will now affect when you are trying to get to, to litigation or trying to get to dispute resolution. So that's why in negotiating this contract, it's very important that from the deal room, we get all of these things right. Otherwise, you get to a point where you can't resolve your disputes or can't resolve it efficiently. And with arbitration, you can design your disputes. You can state, for instance, that dispute should be document only, no need for oral hearing. You can put a time frame to say, look, the dispute should be resolved in 3 months, in 6 months, even though that's a little bit dodgy, but under certain circumstances, it can work. You can shorten the time for filing of pleadings and other documents so that way you can get a decision a lot faster than you get in litigation. So these are some of my thoughts and why I would not blame any creative who thinks going the route of litigation is not really the best. I don't know if Cody is back. I'm sure she would have a few things to add.
Rita, are you still here?
Yeah. Oh, Rita, you're muted. You're muted, Rita. Rita, you're muted.
I said I am. Thank you very much, Max, for that. So I think we've exhausted one. I don't know, Cody, do you want to say anything to the last question, or do I just go over our conclusion and then read the questions from participants that we already have in the comment section? Cody?
Yes, apologies. I've had to switch networks, so yes. So could you take that again, Rita? I believe that I am. Hello? Can you hear me, Rita? Yes, what was that,
Yeah,
please?
I can hear you. So the question I asked Max was as to the question I asked Max was as to whether we Max, is as to whether we see litigation as failure, litigation as failure or strategy, and if you could rewrite one industry practice tomorrow, what would it be? Before I ask both of you your last questions. But did you hear the question? Hello, Cody.
Yes, I heard the question, and I heard. Okay, I was able to hear Max. Hello.
I can hear you.
Cody, I can hear you.
I can hear you. Okay, I think Cody is still having issues on network, so let's just wait for her to come back. But Max, let me ask you my final question before I ask you. Someone wrote exam questions. I don't know how you want to answer that and who is going to mark it. But my last question to you is what would you consider the most dangerous clause? A clause that favors deals, clause that ends, and what's the final one, man? Let's see. The final one is, I don't know. The final one is most ignored clause that you've come across. Can you hear me?
Okay. Yeah, thanks, Rita. So I'll talk about some of the dangerous ones I think I've seen. So for me, and maybe to hark back to the last question, I didn't answer the last part of it, which is if there's one industry practice, I would want to see changed.
I think Max network is buffering, or is it my network? Can you guys hear Max?
You're right.
I can
only with
I don't know if you can hear me.
Okay, Cody, are you back?
Cody, you're back.
I'm back. Hopefully for good. There appears to be I've been struggling with.
We're in Nigeria. Don't worry, we understand. We're in Nigeria.
I believe I'm back. Yes.
Okay, over to you before Max will continue. Max, if that's fine by you, is that fine by you?
I think it's Mark's turn to experience Nigerian network happenings. I can see he's frozen on my end.
Okay,
but I hear you on dangerous, what I would consider dangerous clauses, right?
Yeah, so most dangerous clause,
okay.
Most ignored clause, clause that saves deals, and clause that ends deals.
Okay. A key clause, a key dangerous clause, and you had kind of touched on it in the beginning when you had reference to morality. And I think someone had even specifically asked for some more clarity on that specifically, because in that sense, and I use the example of Tiger Woods, just the fact that there is an endorsement deal and then the relationship or the reason why that deal comes to an end, is because of the reputational damage, what the company will consider, the brand will consider reputational damage to the business, right? So it's a dangerous clause in the sense that for the talent, depending on whose side one is being on, for the talent, it brings the whole deal to an end. It affects the talent's ability to generate revenue from that specific deal for the fact that you are not able to keep up with the terms of that specific morality clause. And interestingly, it's usually kind of couched widely. It's not very narrow in the sense of what would you consider reputational damage to, for instance, a brand like Nike, if the brand ambassador is, caught doing something, or, there is maybe a possible criminal case pending, whatever it may be, right? The effect on it makes that clause a dangerous one for the talent or for the person involved. There's that challenge. I'll call that dangerous clause. Another one as well is if there's an absence of no injunctive relief or right to injunctive relief. And I think that's a dangerous clause, particularly on the side of a company, if you are advising, especially for a film production company, if you do not contractually limit the right for a party that you are negotiating with or entering into arrangement with, where you'll be using their services. Let's use, for instance, a talent such as a performing artist, as an actor in the film as well. The fact that the actor can then, raise an injunction or go to the courts to get an injunction to stop the film from being shown, coming out, your theatrical release gets delayed for weeks, for months. Meanwhile, you've already had your arrangement, of course, with the distribution company, the likes. Those kind of deals, those kind of clauses that would affect your commercial rights, you have an ability to recoup for your clients. If you're on the production side as well, that is a dangerous clause that could also end a deal, really. But a clause that would save a contract, I would save a deal, will be to include that. And most importantly, the force majeure clause. I mean, I don't know how many of us are aware, the Top Gun movie Maverick was supposed to be released in 2019, 2020, and the likes, which was in the height of COVID. No one was going to the cinema. I just want the screen. I'm not getting the impression that I'm being heard. I'm just going to quickly check the chat.
I can hear you. I can hear you.
Oh, thank you. Thank you very much. So that would be, yes, having a force majeure clause would definitely save a deal, because, for instance, with Maverick, they were able to then release in 2022 when people
I was
were going to the
hearing you, but
cinemas,
I
right?
think you're buffering me.
Yes. So is it better now? Any improvement? Yeah, Loretta says loud and clear. So let me go with Loretta's response. So having a force majeure clause, yes, would save a deal, because there are, possibility of a pandemic, possibility of war, possibility of riot, possibility of strike, and how that can affect, for instance, a film production, album release, in the sense that, those that would make up the revenue, those being able to go to the cinemas, for instance, would then not be able to, you wouldn't be able to make that profit, make that revenue, because there would be nobody to attend to it. Or even in terms of performing the contract, you're not able to then perform because there's nobody available, there's been an act of war, everyone is in hiding, etc. thereabouts. Those are some quick clauses that definitely would have the those kind of impacts.
Okay, thank you very much, Cody. Max, do you want to continue?
Let me. It's Mark here. Let me quickly add another one that would save a deal, derivative work. So there's not as much, there's a lot there. There's a lack of maybe consideration that I have seen in terms of being able to exploit, for instance, and I'll still use film as an example because of how broad the exploitation rights can end up being. If you do create a film and is so successful, you want to be able to create a sequel, create a derivative work. You're now having to be able to check what kind of relationship, contractual arrangements you've had with investors, with co-producers, whoever else is involved in the filmmaking, to see what enables you to be able to create that derivative work. Unwittingly or knowingly, there are instances where parties would then, put themselves in situations where they co-own
Cody's network. I don't know if it's just me, but I can't hear Cody anymore. Max, can you hear Cody?
Yeah, Rita. Yeah, Rita, I can hear you, but not Cody. But I agree. The point Cody was, the last point she was making, with respect to some of those clauses that really are very troublesome. But she's right that forget derivative works. So typically an agreement. But you forget that if that movie becomes a success, there can be merchandising of items from the characters in that movie. So people can do T-shirts, sweaters with the main character, say Achalugo, for instance. People can do tea items, teacups, mugs, and all of that from from a popular character in a movie. So without properly accounting for how derivative works like that, I mean, of course, and then the other derivative works, there could be a translation of that movie into another language, maybe into Russian, into into any other country, and somebody wants to exploit the movie in that country. So these are things that a lot of agreements sometimes do not provide properly for, and then they can become the basis of dispute. Because one party is saying, look, we did this movie together, and without my knowledge, you've translated, you've put the movie on a streaming service that broadcasts the movie in Russia, and they've translated or put subtitles or used AI to do a voiceover, in Russian for that movie. So that can become a challenge if the artists would split on those derivatives, who has the right, and whether you can take those derivative works without permission of the other party. Then on my own part, one of the clauses I think I find troubling, I would say troubling perhaps, maybe not necessarily dangerous, is how widely the assignment of right clauses in most entertainment deals are structured. A lot of times they are too wide because people are not aware that, particularly with copyright, you can slice up a copyright into many smaller rights and grant only specific rights, say in the context of licensing. So it is possible to grant the person the right to use your copyright only in a certain location, only in Nigeria, only in the US, or only in Europe. You can also grant the right for the type of use that can be made of that work. Talking about derivative works, you can grant the person a specific right to exploit the movie in Russia and translate that movie into Russian. But what we find more often than not is that creatives are made to assign all their rights, global rights, without any limitation. And I think it's not necessarily beneficial to our creatives. And it's really an industry thing, because if you
I think we've been continuing for where the other stopped. Our apologies. I mean, right? So when it rains, it pours. Yes, the network is quite poor. But that is the point as to assignments of wide assignment of IP rights and the effects it can actually have. And as lawyers, it's our duty to be able to advise our clients appropriately, so that the appropriate value, the value that is goes with the amount of intellectual property, their exchange that is being made. They must be commensurate with, if it's an assignment fee, where there's a license, where there's royalty payments expected, to ensure that our clients are getting the best value actually for that. I think I'll add that to what I know that Mark was saying.
Yeah, okay. Thank you very much, Cody. I think you finished that point well. I was just wanting to add that is one industry practice I would like to see change, because the way it works is that it's kind of standard, that wide assignment of rights. And if you don't sign, they'll just throw you away and go to the next creative who is happy to sign. So it's really an industry culture thing. I really hope that we would see that change in the industry, where, maybe artist unions. So for instance, in Hollywood, is because, say, screenwriters, they have a very strong association. So if you put certain terms, clauses in agreement, and they refuse to sign, you will not get any writer in Hollywood to write for you. So we need to see our artists also bind together that way. have pressure groups that can really, I mean, and nothing stops artists, for instance, from registering trade unions, really, to protect their rights. So, I mean, backup vocalists, for instance, can register a trade union to say, look, any contract that says we must assign our global rights, we will not sign. And that way, if every vocal artist says the same thing, then it means that you will have to, deal with them, or otherwise you go somewhere else to look for a vocal artist. So I would really hope that we begin to have more of that in the creative industry, where they're buying together and they're able to negotiate and change industry culture to their favor. Thank you.
Okay, thank you so much, Max. So let me just I think we'll just take like one question each for both speakers. So there's a question here. It says, please expatiate further on why arbitration is generally not allowed in public policy. In my view, if the cost of arbitration is more than the financial matter involved in the dispute, it will not be ideal to opt for arbitration. Other ideal methods such as mediation can be opted for. So I don't know if you want to say one thing and probably touch on the conversation as to, I don't know how to feel about this question, but it says, how do we get judges to be abreast with peculiar nature of sports and entertainment deals? I'm on my knees. So the person that has this question, don't implicate me. I'm begging you. Max, why you answer
okay,
thank
you. Yeah, thank you. So let me start with the first, which is the issue of public policy. So the whole idea of public policy is that public policy, as the word suggests, are policies set by government, and governments want to be in control of how the policy, direction of their countries are. So when we talk about, even in litigation, also you see sometimes there are arguments that certain matters are matters of public policy, and the court should not, interfere, because the legislator and the executive usually are the custodians and the directive mind of public policy of a nation. So when it comes to arbitration, the thinking, and I'll just try to explain again, is that a country, for instance, gives a patent as a monopoly for 20 years. But when they give that patent, they are trying to promote certain policy issues. They want maybe more innovation in certain areas. They do not want a private arbitration panel to be able to now decide to say, no, this is invalid, because that arbitration panel, not being a government agency, is now allowed to determine the policy direction of a country. So that's usually why we have those challenges about arbitrability of public policy matters. Now, on the part about how we can get the judges up to speed, it's quite a difficult issue. Some countries have specialist panels. So in the UK, for instance, we have the technology and IP courts. What I have always recommended is that it's not practical to form a new court every time we have an issue. So we have the National Industrial Court. I don't think it is wise to have a whole new court that is the maybe entertainment, sports, IP, and all of that court. What we can do is that at the level of the Federal High Court, we can have specialist judges who would handle these matters, and they can sit in divisions. So that would be a way to ensure that people who already have knowledge of these matters are the ones who decide those cases. So that might be, because I mean, everybody wants a specialist court. The EFCC says, give us a special corruption court. Everybody wants a special court, and that's not really solving our problem at the end of the day. But we have judges who are specialists. So it starts from the point of appointment of judges, that judges who are specialized in IP, in maritime, in aviation should be appointed, and there should be an IP bench, and a few judges who are specialists in that area should be the judges who handle those cases. Of course, there'll be a lot of give and take, and a lot of administrative, reworking of the courts to ensure that those cases come before those specialist judges. But that, for me, would be a good way to work around the lack of in-depth knowledge. Because I mean, I pity our particular federal high court judges. The same judge sits in the morning. The first case is handling is an NDLEA case, a drug-related matter. The next case is a commercial oil and gas case. The case after that is an EFCC corruption case. After that is doing a maritime case. He's doing an aviation case. I mean, just one person. It's really difficult to have one person have that kind of breadth over so many things. I mean, at appellate level, because there are many of them sitting on the panel and assisted by counsel, it's easier for them to get it right. But at the trial level, I think it is wiser when we have judges who are a little bit more specialists, or at least have a commercial bench, and ensure that that commercial bench judges are the ones who handle these commercial matters. That would be my thought on the way forward. Thank you.
Thank you very much, Max, for that insightful response. So we have a question. I think the conversation about morality clause is like the hot topic for today. because someone has asked that Cody explains morality clause briefly. Because we're running short of time. Then I want to read a question from Lutana, which says, hello everyone, good afternoon. So a question was forming in my mind during Cody's last response. How valid would certain assignment clauses be where, for instance, the assignment cover exploitation of the work in situations that are yet to, I don't know if it's yet, but let me go with yet to exist, e.g. future tech, future territories, e.g. Hello Mars. I ask this because I recall that the music labels sort of faced this issue at the advent of streaming, I believe. The labels argued that their contracts with artists covered streaming exploitation, but I think the artists who went to court on this issue prevailed against them, with the court saying that their contracts only cover the physical exploitation and not digital. Unfortunately, I do not have any case right now at hand. Yes, sanctity of contract exists, but I'm thinking, does it all boil down to the drafting regardless of the scope of assignment, and would there be some consideration that would influence such clauses? And someone is asking again for the recording of the webinar on entertainment contracts and what's that one? Some of the instruments of transaction and transfer of sports entertainment aspect of law, if they are sample draft. I mean, I'll say if you go on LinkedIn, you might find so much, right? There's a guy I follow on LinkedIn, he had posted something on sports contracts. It was players' contracts, like an industry template. I can't seem to remember his name. But I'll let Cody answer the question, and then we'll have the SLP committee chair on TMT come and give us closing remarks. So Cody, in let's say 1 minute and 30 seconds, can you answer the question that I just read out for you?
Okay, thank you, Rita. So morality clause is simply a clause that is saying that there is a breach or that will trigger termination of the contract where the talent, for instance, or if it's an influencer, has failed to, ensure the reputational or has caused reputational damage, reputational harm to the brand or company, whatever the situation may be. For instance, in a film production, if there's a talent and there's an actor being employed to act in the production, and then there's a morality clause saying that nothing you will do will put the production company in disrepute in that sense, and it would typically, they do not go into details as to what that would be considered, what action would trigger what is considered disrepute or reputational harm. Of course, the company will where the talent ends up, maybe getting arrested for a crime, or ends up saying something that is contrary to what that brand represents, that deal can actually close and be terminated as a result of that, putting it plain and simple. The next question in relation to exploitation, and I hear you because the Nigerian law is very clear. We can see that it favors the author and the original creator. So while the contract may provide certain terms and provisions as to assignments and as to sharing, the fact that the contract is silent on maybe, and is not using, the contract has been drafted too narrow to just say, streaming, or to say any form of distribution, not saying any form of distribution later to be developed, but later to exist. You're not using such terms. It is possible that the court, considering that and considering the rights that the law provides already favoring the author, can go in line with what the law provides and choose to favor the author. If we then look at, they may review the entire agreement and see how much benefit the author has made from it. Was it even an unfair bargaining position in the first place, in which the author, artist, whoever initial author of the IP, very important, or initial creator of the IP, what position that person already is. The court may not be minded if it's going to be an unfair benefit that this film persons on my mouth always goes there. So the benefit that the production company or the company, whoever may have the higher bargaining power, stands to gain, the court may look at that and then make some kind of equitable decision on that. So it is always best, of course, to draft the clause as wide as possible, even if we don't, of course, we are not future, we can't see to the future, we don't have a time machine, so you can't tell what's going to come up next, but you can use your drafting style to reflect it, that all that is contemplated. Thank you, Rita.
Thank you, Cody. So I'm just going to read one feedback. Hold on, let me look for it, because when I read it, I was just smiling. But let me read the feedback. It says, where's it now? Where is it? So, it has been an impactful session. Many thanks to the organizers. Sorry?
Oh.
Yes.
No, carry on. Sorry, I wanted to just make a recommendation in response to the questions about where to get good drafts. So I wanted to recommend a book written by a Nigerian lawyer, Michael Dugeri, Entertainment Law in Nigeria. He has a lot of good drafts in that book, artist agreements, film production agreements, lots of drafts.
I know a copy here.
Templates.
Whoever wants it, but don't buy during AGC. They'll cheat you. Some pages are missing from this one. Don't buy during AGC. Buy from Adejumade's Legal Nigeria page. I'm sure you have the full. Yeah, and then you have Dr. Olowanoni. Let me see. Yeah, Dr. Emmanuel Oluwafemi Olowanoni. He has a book on sports law, and then Beverly has like a mini book about A to Z on sports law and another one on entertainment law. For contrast, I think I'm just going to give you guys my own expo. I usually find a lot of entertainment, sports, media conversations on LinkedIn. So just go to the search bar and type whatever it is you're looking for, and you see it there. FIFA just released its CAS quarterly report for 2025. So if you have an interest in arbitration or sports disputes, you can check that out. There are a couple of other people on LinkedIn as well that publish entertainment-related content, right? I would say, I can't remember the guy's name, but he published the merger agreement between Netflix and Warner Bros. Last year. I think about 250 pages. But in all, I want to say a big thank you to everyone who participated, comments, not those that were sharing their SCN number, right? But every other person that commented, thank you so much. I don't know if Fernandez is online to give his closing remark. Dami, is Fernandez online? Dami?
Okay.
I don't know.
Hi. Can you hear me?
Yes, I can.
Okay, so the vice chair of the MBA SLP TMC committee, that's Rita Uche, she's giving closing remarks on behalf of the committee chair. So,
okay, so over to you, Miss Rita.
Okay, so for some reason, can the host please make Rita a co-own? My device is hanging really bad. Or allow Rita to unmute. Can you allow Rita to unmute?
Hello.
Rita,
yes, I'm unmuted. Okay. So as we come to the close of today's Zoom session, from deal room to courtroom, when sports and entertainment deals go wrong, which was organized jointly by the NBA SLP and the SBL. I would like to extend our sincere thanks to everyone who has made this session such a resounding success. So as a media lawyer, I found this very insightful, and a special note of appreciation to our moderator, Rita, whose guidance and seamless facilitation has kept this discussion engaging and focused throughout. We're also deeply grateful to our distinguished speakers, Madam Folashade Ali, SAN, the chairman of the MBA SLP, and Madam Azofo Latunde, the chairman of the MBA SBL. Fernandez Marcus, chairman of the SLP TMT committee. Max Ikombe, founder principal of Everlaw Associates. Tolu Olaloye, Kodichi Anibogo, senior associate Jackson Eti and Edu, for sharing their expertise, real-world experiences.
Sorry, Tolu is the chair. Sorry, Rita. Tolu is the chair of the MBSBO Sports, Entertainment and Media Committee. So, even though she works at JE, but she's the chair of the committee. Sorry about that.
Thank you, Rita Chinda. Well noted.
Okay.
Okay, so where was I now? Rita, you're going to have to continue. Okay, so thank you to all. Yes, it's fine. It's fine, totally. Thank you to all the speakers for sharing their expertise, real-world experiences, and valuable perspectives. Your insights into the legal, commercial, and practical challenges in sports and entertainment deals has truly enriched the conversation and provided immense learning for all of us. So also the secretary of the TMT committee in person of Damilola Alabi, the TMT committee of the MBSLP, I mean. And also heartfelt thanks to the over 700 attendees who joined us today. Your active participation, thoughtful comments, and keen interest made this session lively and impactful. Well done. And finally, thank you to everyone behind the scenes who contributed to the smooth execution of this session. We truly appreciate your time, support, and enthusiasm, and we look forward to engaging with you again in future sessions. Thank you, everyone.
Thank you, Madam Vice Chair. Rita is also my namesake. Even though she didn't turn on her video, but it's fine. Thank you to our participants.
You can see me, it's fine. You disabled it. I tried to turn it on, but then they say you have disabled it, so I didn't want to.
Yeah, okay, so my
bad. I should have asked you to do something about that, but it's fine.
No worries, no worries. But anyways, thank you. Thank you. I'm even surprised. 700 or something. You guys stayed with us for an hour, 30 minutes and counting. Thank you, thank you, thank you once again. Have a good afternoon, everyone. And thank you to the MBSLP TMT committee and the MBSBL Sport Entertainment and Media Committee for the opportunity to moderate this session. To Max, my mentor of life, your insight as always fantastic. To Cody, thank you so much for the insights. We all experienced bad network today. I'm sure you guys will forgive us for that, but thank you and have a good afternoon. See you at the next SLP session. Bye, guys.
Thank you. Bye, everyone.